in your investigation and looking at all the hours of videos, did you ever see Kyle act inappropriate towards somebody who was not threatening him with a firearm?
Objection, relevance.
Again, I'm going to
Relevant.
sustain.
Government just doesn't want to hear the truth.
Mr. Richards, here's the key. You have an opportunity at trial, but we're here at preliminary hearing. I understand perhaps you're frustrated, but perhaps we continue the examination.
It was fascinating today to watch this Zoom hearing, and everyone's in their own little space and they kind of are interacting on the screen, but both the prosecutor and defense attorney have a little edge and a little bit of attitude. The prosecutor, a little bit of sarcasm in the way he presents it, and then you heard the way Mark Richards, the defense attorney, is. I guess you don't want to hear the truth, right? Unbelievable. Let's take a listen to a little bit more of Mark Richards making his arguments today.
When one looks at the laundry list of charges the state came up with against my client, it's clear that if in fact this gun was a short-barreled rifle, he would have been charged with the felony count of possession of a short-barreled rifle, contrary to the statute, with additional penalties. The government talked about, well, this is for hunting and things like this. There are two other prohibitions that are set forth in the statute. Wisconsin Stat 29.304 only applies to people who are under the age of 16. Consequently, it does not apply to Kyle. The criminal complaint sets forth my client's birth date. He was 17 on August 25th, 2020. As to 29593, that has to do with hunter certification. If an individual is out hunting, and that's what Mr. Binger was hanging his hat on. There is no allegation anywhere that my client was hunting on August 25th, 2020. So it does not meet the requirements of statute 948.63. The statute is clear on its face, must be construed strictly to my client's benefit. Additionally, what the government is trying to seek is an impingement of my client's Second Amendment rights, which is not covered by this statute. It's very specific regarding when it's a misdemeanor, what it applies to, and there's basically three prohibitions, none of which are met. The statutory history, which is included in the brief, makes that clear. Count 6 should be dismissed.
Even just watching some of the body language from both sides during this was unreal. Let's bring back in Julie Grant and Michael Ayala. Michael, I'm going to start with you on this. I mean, he's carrying a little bit of attitude into today's hearing, wasn't he?
Yeah, no doubt. Even in that little segment we just saw, he starts off by saying, had he had a sawed-off shotgun, surely, Judge, you would have seen that charge because they basically charged him with everything they possibly could. That was sort of his statement about how he feels about the prosecution. But I will tell you this, Vinny. Once this was brought up, I did some digging, did some research, and there is a reading of the statute that suggests that if you're under the age of 18 but over 16, that there is a way that the statute can be interpreted to say you're allowed to have a rifle because it's not sawed off. Sawed off is what they're trying to sort of restrict. But other than that, you can possibly, and you can see that in Wisconsin, right? It's a gun-friendly state. The lifestyle there, rifles are a part of life in many areas, a lot of rural areas, agriculture, and they don't want to limit 16 to 18-year-olds from possessing a rifle, but they're saying the sawed-off type are the ones that sort of present a problem. So there is a reading of the statute, so while it might have sounded sarcastic on that level, I think there is a reading of the statute that he might have a case for.
Yeah, I think he'll bring the motion again now that they're getting in front of the trial judge. Julie Grant, what did you take away generally? Because if these two attorneys are trying this case, I think it's going to be fireworks in that courtroom.
It sure is, Vinny. I can't wait till these two attorneys get into the courtroom because today, I mean, they both look like they were ready at certain points to jump through the screens on the Zoom hearing. I mean, these are very, very zealous advocates, which is exactly what you want on each side respectively. on a case like this. This case is so high profile, so many eyes on it all over the country. These lawyers are obviously highly intelligent, highly skilled, very experienced, and they believe in their cases. And that's really what matters here. I mean, this was evident to us just in the short prelim today. I mean, this was short and sweet. You know, kudos to the prosecution for keeping it that way. And you could just see how they can't wait. They are chomping at the bit to try this case. And I have to hand it to defense counsel, too. Tip my hat to him as well, because he did everything he could to try to draw this hearing out and introduce all the evidence he could to try to put his story out there. Because we know at the end of the day, trials are about who is telling the best story and using that evidence to tell a compelling story. And I think there are going to be fireworks in that courtroom. These advocates believe in their respective sides. They believe in their positions. They know the law. And I loved watching this today. I love watching good advocacy. And I think this is just a preview of what's to come in this case.
Yeah, as a guy from Jersey, I appreciate anytime the attorneys bring a little attitude into the courtroom. Let's take a listen to Thomas Bringer, the prosecutor, who I thought had a little bit of sarcasm in his voice today. Let's take a listen.
There's no dispute in this case that Kyle Rittenhouse armed himself with an AR-15 on August 25th, 2020 at the age of 17 years old. That's it. It's that simple. Now, if the defense wants to hide behind hunter safety regulations to try and excuse that behavior, then I'll simply quote back what Attorney Richards just said, which is the defendant wasn't hunting. It wasn't hunting season. This wasn't a kid who went up north with his dad and a shotgun and went hunting for deer like last week during hunting season here in Wisconsin. This was a situation in which a teenager went running around the streets of Kenosha after curfew with a very dangerous weapon. And this is exactly why we have this law, because a teenager in this case killed 2 people and shot a third, because teenagers shouldn't be allowed to run around with dangerous weapons, because bad things happen. They don't have the judgment, they don't have the experience. We don't trust them with these weapons because of exactly what happened in this case. Now, the defense seems to construe this statute as requiring that we plead their affirmative defense. I don't construe it that way. There is no requirement that we allege that the subsection 3C exception doesn't apply to the defendant. There is no dispute it doesn't apply to him. No one is alleging he's complied with hunter safety regulations or has a certificate or has done the class, or that this was hunting in the traditional sense of the word. This was hunting humans, not deer.
I want to start, Julie, with that last. Do you think that is going to be the theme in front of the jury, that the 17-year-old came to Wisconsin to hunt humans?
Vinny, that would be an outstanding theme. And when he said that, I thought, that was the line of the day. That was the line from this hearing that stood out to me more than any other line. And that's something that resonates with people. I wouldn't be surprised if we see some newspaper headlines maybe tomorrow using that quote from the prosecutor. And I think it's especially important that he does have a theme, as you mentioned. I mean, sometimes when you have a case, a theme needs to go throughout it, and good lawyers understand that. And when you have a case like this, a lot of times you see people think, well, why? How did it get like this? Why? Why are we even here? Especially if you're one who hasn't followed it closely or understands the particulars. And that right there, this was hunting humans, not deer. What a powerful statement. And if he were to use that thematically and say that Kyle Rittenhouse was on a mission that day, he went on a mission to go hunting. He grabbed it. And he, just like he told the little story you saw there in that clip, this wasn't like he went up north with his dad on a weekend on hunting season. Just he gave you a visual picture right there in that little clip. If he does that with the jury and has them visualize that day as a day where he went out with a purposeful mission, the prosecution will have an excellent chance at prevailing in this case. And I'm sure the defense will certainly have their own version to combat that. But I think, as you mentioned, for the prosecution, that's going to be key, and especially with the kind of gun that was used in this case.
Michael, you think the evidence matches up with that theme? Will they be able to put the two together?
You know, I'm not so sure, but I think Julie's right. I think I can even see his opening statement, including that particular statement. It rings like if the glove doesn't fit, you must acquit. It's that catchy and something that I can see him using throughout the trial. But I still think it might be folly to go in that direction. This is a 17-year-old. He does not present as someone who went out hunting in that way. I think if you can get to that theme based on the initial confrontation, that there was a confrontation and essentially these things happened, and he was ready and able and prepared to take that action. But I don't think you can make that argument that he headed down there specifically for that reason. There's too much out there right now as far as the evidence we're aware of, right? We don't have everything that the prosecution has, but as far as the evidence we're aware of, there's too much out there to suggest he was down there for other purposes, to protect property. He's even on video talking about, I have this medical pack because I want to help people. I have my gun just in case to protect myself. So I think that might be hard to start with, but maybe just within that first confrontation, he can begin that narrative.
All right, we shall see. This is one of the big ones, folks. All right, Julie Grant, Michael Ayala, thank you so much. Appreciate it.